So I guess starting with the obvious, what do you need to do to make your will? Well, the first one is committing to making one. It's absolutely amazing how many people mean to make a will, have it on their to-do list, just keep putting it off, don't quite get round to it. Unfortunately, there's nothing so certain in life that we are going to die, and so it's certainly something that you will need at some point in time. And so I would say that the most important thing that you can do is actually to commit to making your will. It doesn't matter that situations might change or that perfect storm is not in place at that time. You can always review it later, and it really is just something that you should commit to getting put in place. Obviously, a bit like Ed, I would recommend that if you're making your will, that you take some professional advice. It's, you know, even if you think that your affairs are quite simple and straightforward, or that what you're going to want is quite straightforward, it's amazing that how much will come out of the woodwork if you talk it through with a professional advisor. We're trained, we know the questions to ask, we've seen things with other clients, we can suggest different options to you that you may not have thought about. And really, it's that thought process and the advice that really goes into making the best will, rather than the piece of paper that you get at the end. And then obviously, once you've made a will, or if you've already got one in place, I would strongly suggest that you commit to keeping it up to date. So many people make one, put it in the drawer, think, right, that's it, done. You know, 25 years later, when it comes to looking at it, they realise that everyone's changed, that people, you know, their assets have changed, their personal circumstances have changed, families have changed, and to be fair, the law has often changed. So it's important that you keep it up to review, keep it under review. You may not need to change it when you review it, but at least you'll have that peace of mind in knowing that you have addressed it, looked at it, and kept it up to date. So what are the things that you need to consider if you're thinking of making or reviewing your will? Well, really, it's the 4 W's. So it's who, what, why, and when. So looking at who first, I guess the most important thing that you need to consider with your will is actually who are you trying to benefit? Who is it that you need to include in your will? Who are you looking to provide for? Who depends on you? What assets do you need to make sure go to certain people? We live in a sort of modern society, really, with blended families. You need to be really clear about what you're trying to achieve through your wills. So if you're a couple, for example, and you've got children from previous relationships, are you looking to include all the children within your family unit and include them in both wills? Or are you looking to make some provision individually for your own children, and maybe make alternative arrangements? Or have some kind of different split, which leads on to really, if you're thinking of leaving somebody out of your will, which is the other big consideration that people do have. Perhaps you've had a fallout in the family, perhaps there's somebody that you've made provision for or feel that you've already made provision for and that you therefore are not making as equal provision for them in your will. There's a lot of legislation and a lot of things that have been in the press about people challenging wills, and taking professional advice and carefully drafting your will can make it more difficult for your will to be challenged at a later date, and can avoid sort of problems for your family when it comes to administering your estate. So the other big who question when it comes to making your will is who will be your executors and trustees. Arguably they are all, aside from your beneficiaries, the most important people that you will name in your will. They will be responsible for taking over, dealing with your assets and your estate, making sure that your estate is divided up in accordance with your will. And if you've included any trust provisions or have any special assets in your estate, they'll be responsible for making sure that they are dealt with correctly and that the trust provisions are adhered to beyond your death. So most people's sort of immediate thought would be, oh, I'll appoint my family members to be the executors and trustees. But really you need to consider, are they the right people? Do they have the right skills? Just for the fact that they are related to you doesn't mean that they'll be able to run your business or that they would be able to mediate if there was any disagreement. Certainly for more substantial or complex estates, having a professional or independent trustee appointed can be worth its weight in gold. The chances are that your beneficiaries would, or lay executors, would need to use a professional person in any event to navigate through the tax legislation or the process of dealing with your estate. And so having a professional person on board that you've chosen can be very useful. And I think the other thing to bear in mind when you're choosing your executors and trustees is to ensure that they will work together. And the last thing that anybody needs, and certainly that would cause a problem, would be if you had executors and trustees that just didn't like each other or didn't get on or weren't singing from the same hymn sheet. And so I think having people that you know will work together, will have your wishes at their heart and have the best interests of your family at heart, and can be balanced and impartial between different beneficiaries is very important. So once we've established who we want to include within our will, the next big question really is, well, what assets do you actually have to leave? And setting that, looking at that as a holistic way. So there's obviously the obvious things that everyone thinks of, the house, a bank account, possibly your treasured fishing tackle collection. But there are other things that are included in your estate which you might not have thought of and which might be included in your will. And there are other assets which you maybe think would be part of your will but are actually dealt with separately and outside of the terms of the will. So, for example, if you own property jointly with somebody else, you may not realise that joint property usually goes to the surviving joint owner, regardless of what's mentioned in your will. So, for example, if you had a joint bank account with your son or daughter for any reason, they would automatically inherit the bank account. If other things that are outside of your estate are your pensions. So your pension fund is usually controlled by the pension company or the pension trustees, and they will look at your nominations and letter of wishes, things that you've told them that you would want to happen to your pension scheme after you died. They may look at your will, but they're not governed by your will, and they can decide for themselves how they will distribute your pension after your death. You can't dictate what happens to your pension through your will. If you've made any of the lifetime trusts, such as those that were mentioned by Ed earlier, they will be distributed by the trustees that you've appointed to deal with those. Again, they won't be covered by your will, and so it's important to understand how these different things will all interact, perhaps what provision you've made for different people under different pots, so that you can tailor your will to deal with the assets that will be covered by that and make sure that they will go to the right people and that an overall sort of fair distribution, or the distribution that you want to say will happen, of your estate. So again, when we're looking at what assets we've got in the estate, we're going to be looking at what assets might need some special treatment under the will. So there could be, this could be things that get special treatment for tax, such as shares, business assets, farms, agricultural land, or as Ed was talking about earlier, the main residence. So in order to capture that residence nil rate band, it's important that the residence is treated separately in your will, or in a way that doesn't hinder that relief being able to be claimed. And the classic one for that really is actually people who are leaving their residence to grandchildren with a contingent age gift. And that's the most common scenario where people don't realise that would actually preclude you from getting the residence nil rate band. Also, as Ed alluded to earlier, certain trusts in wills wouldn't automatically qualify for the residence nil rate band, but can usually be adapted so that you would be able to get that relief available. So it's important to take advice about the different assets so that you understand how they would be treated on your death and what special provision might need to be made for them in your will. This is possibly a little bit more niche, but some people have certain assets which your everyday person, even your everyday solicitor, wouldn't be able to deal with. So for example, I have a client who is an author, and in his will he has appointed a separate literary executor who will be responsible for sorting out all his intellectual property rights and the royalties that he gets from his works. And that person will just deal with that aspect of the estate, and he's got ordinary executors, for want of a better word, to deal with all the other day-to-day parts of the administration of his estate. So some assets do need a specialist knowledge, and that may feed into your choice of executors and trustees. So as I alluded to earlier, if you've got a business, your family members might not be the best people to carry on running that business, or to liquidate it, or to be able to bring that to a conclusion, or even to arrange for it to be sold. It may be that you need some professional people in there, and you may want to appoint executors either to just deal with that aspect, or to sort of deal with the whole administration of your estate and guide the family through that process. So moving on, once we've decided who we're including in the will, what we've got to leave, then the next big thing really is to be clear about why you're making your will. What is it that we're looking to achieve when we're making this will? Everybody has their own sort of considerations, their own things that are important to them. So a bit like Ed had mentioned earlier, for some people, they're not bothered about inheritance tax. That's not their big drive. It's not their big important, the main focus of their will. It may be for them that it's more important that they make provision for a particular person, or that they have a very simple structure that they can understand. For most people, the sort of starting point really of why we make a will is to sort of give certainty and to give peace of mind, both for you and for your family. Having a will in place, everyone understands that what you wanted, and what they're sort of working towards as we're administering the estate. The clear driver for the vast majority of people is also to provide for their family. But for the provision for family is very different for different people. And how we need to provide for that will depend on the makeup of your family, and it's a very bespoke thing. Obviously, for some people, the driver will be about preserving wealth so that it can do the best for their family that it can. And for other people, it is about tax, making best use of tax relief, making sure that the minimal amount of tax is paid. And then, as I've just mentioned, really, the sort of final one is really about protecting wealth, stopping it being wasted or in some way filtered out of the family, or perhaps to make provision for people who would be vulnerable. So as you can see, you've often got some competing interests to balance. So on the one side, you really, if you were to come at this from its most basic point of view and you just said, right, I need a will, I'm just going to leave everything to X person, keeping it simple. Everyone's got the most freedoms, they're free to do whatever they want with it, that's it. It's all on the one side. And then you're balancing against that if you're worried about protecting those assets, or providing for people, or putting security in, or looking after vulnerable people. You're weighing an element of protection against that freedom all the time. So the final W in my sort of W scenario is that you would need to consider when you want people to inherit. So, for example, if you were in a blended family and you had a new spouse and you have children from a previous relationship, are you wanting to make sure that your children got something on your death, or are you happy for them to wait and maybe only inherit after your spouse has passed away? If you've got children who are going to be inheriting, at what age would you want them to inherit? Do you want them to get some of it at a younger age, with some held back until they're older? At what age would you think that they could take over the reins, if you like, of dealing with the money as against the executors and trustees? And what provision would you want the executors and trustees to make for them whilst they're under that age? And then there may be other special circumstances that need to be taken into account. For example, I had a client a few weeks ago who provides a home for his mum. And so it's important for him that her needs are taken account of. If anything happens to him, one of his big concerns is that she would still have a home to live in, and that she couldn't be turfed out in order to give money to other family members. So we were looking at sort of when you would inherit. And then the other big when really is, when should you make your will? When's the good time to do it? And I would say really, as soon as you've got assets that you mean you've got something to leave, or that you've got people that you need to provide for, then really you should have a will. There's no perfect time to make one, there never will, and if you hold out for that opportunity where all the sort of stars have aligned and everything's in the perfect place, everybody's in, you know, in good relationships, is settled and stable, and you can understand how you want it to be, then you'll probably never get round to making one. It's much better to have a will in place. We can usually work with that. If the worst case scenario happens and you haven't updated your will, your beneficiaries can usually come together and do what's called a deed of variation and rejig things. But if you haven't got a will, quite often those options to do that are very limited, possibly because you've got minor beneficiaries involved, you know, children who are under the age of 18, or maybe because people are involved who you wouldn't have wanted to be involved, purely and simply because they happen to be of a degree of relationship to you that means that they would qualify as a beneficiary. It's important to remember as well that you can always update your will, so it doesn't matter that things might be in flux or that might be changing, because you can update it. You would, you know, if you think of it like an insurance policy, but one that's definitely going to be needed, you would review your insurance regularly to make sure that you had sufficient cover, that the right cover was in place, and it's no different with your will. You should just be keeping it regularly reviewed and make sure that it still does the job that you want it to. So looking at specifically at tax efficiency and protection in wills, if these were things that are of concern to you, what would we be expecting to kind of discuss with you or put into your will? So the first one would be to make best use of those tax allowances that Ed was mentioned earlier. So particularly things like business property relief and agricultural property relief. If you made your most basic will and left everything to a surviving spouse, you'd basically be wasting that relief. You've got an opportunity when you go and you're holding on to those assets at the day that you die, you've got an opportunity to pass those on tax-free. Because they don't attract any inheritance tax, you can pass them to anyone tax-free. So it's almost a waste to pass them to a surviving spouse who wouldn't pay tax anyway, particularly if there's a risk with something like business property relief that the company would then be sold and that relief would get lost because the business asset was being converted to cash. That would obviously have the effect of immediately boosting your spouse's estate. So it's much better to look at capturing those reliefs whilst they're available. And that could be an outright gift. So, for example, company shares to the children would be the obvious choice. But for a lot of people, that is not really an attractive option, either because they don't want so many people having control of the company or having a say in the company running, or it may be because they need the dividends from those shares to be able to be available for the surviving spouse. And if that's the case, then we would recommend that you use a discretionary trust to park the shares into a vehicle where they can still be used to benefit the spouse, but also can be used to benefit the wider family as and when it's appropriate. The second sort of available allowance that we look to make sure that we capture in your will is that residence nil rate band. So making sure it's going to pass to lineal descendants without any of the trusts or contingencies, or making sure that we have a flexible enough trust where it could be rejigged if needed afterwards. And also you need to consider whether you're wanting to use that allowance on first death or second death. So for some people, they can use it on first death, particularly if they share a home with their children or whatever. And we use it then so that if the residence relief for any reason is withdrawn later, it's being used in and sort of moving on a sort of similar theme really, we would look at whether or not you should be using your nil rate band allowance, your ordinary nil rate band allowance of 325,000. That used to be a very popular tool, if you like, in the tax planning in wills. But more recently it's kind of fallen out of favour when the government allowed you to transfer your allowances between spouses. But if you've got an estate that's likely to be knocking on the door of that £2 million where you would get your residence relief withdrawn, then it's an option is to kind of reduce the value of the surviving spouse's estate by hiving off that nil rate allowance, either directly to children as outright gifts, or again using a trust as a vehicle to park it, so that the surviving spouse can still be a beneficiary as well as the wider sort of family members. And then finally, we would also look in your will at whether or not you want to try and take advantage of the charity exemption that's available. So a few years ago, the government introduced a sort of incentive, if you like, for charitable giving, where they will reduce the rate of inheritance tax on an estate down to 36% if you're leaving more than 10% of your estate to charity. Now, it's quite a complex calculation of how they come to that 10%. But if you were already thinking of leaving money to charity in your will, this can be a really favourable thing for you to consider doing. I think it equates to around a 5% tipping point. So if you were already going to be leaving 5% of your estate to charity, bumping it up to 10% has very little effect on your ultimate beneficiaries, because effectively the taxman pays that additional amount to the charity. The charity wins, the family stay the same, but the taxman loses a little bit of his tax. That can be quite attractive. So moving on sort of from the tax side of your wills planning, there's also the protective element. So one thing that we usually discuss with people is how to protect assets when the first one goes. So for some people, what they're worried about is maybe care fees, so the surviving spouse needing to go into care and the money being lost through paying for care. They may be worried about spouse remarrying and leaving all the money to a new spouse or a new spouse's family, with children sort of being disinherited. So if we've got those sort of situations in place, then what we can suggest to people is a flexible life interest trust for the surviving spouse. And what that looks like in reality is that instead of the spouse taking all of the assets outright, they're instead got like a fence put around your share of the assets or your assets in your will, and after you die your spouse is entitled to the use and benefit. So maybe if it was a property, they'd be allowed to carry on living there. If it was money in accounts or investments, it would be the right to receive the income from those investments. But the trustees retain control of those assets and can keep an eye on what happens to them and make sure that they're not dissipated elsewhere. The spouse couldn't just spend it all or give it away. A sort of sideline advantage of that arrangement really is for those people who maybe got a surviving spouse who is vulnerable or perhaps anticipating some sort of long-term ill health, because the fact that these assets are in trust will allow the trustees to control the assets and will allow sort of lifetime gifting to carry on effectively by the back door. Even though you might have things like powers of attorney in place, attorneys are not allowed to make gifts. So if the surviving spouse has a particularly large estate, and for example you're worried about that £2 million being milestone mark being breached, the trustees could perhaps terminate the interest in some of the trust fund, kind of reduce the overall value of the survivor's estate, and that would effectively be treated like a gift and reduce the value perhaps down below the 2 million. So it can have some other longer term benefits as well. And then finally, people often want to think about including trusts sort of beyond the tax planning aspect. So we've talked about the use of trusts to perhaps claim the BPR. We've talked about the use of trusts to protect assets during the survivor's lifetime. But there may be people in your family who would benefit from some protection longer term, or it may be for your family that it presents a good tax planning strategy to maybe bypass the generation and have funds in trust for grandchildren or great-grandchildren and provide funds for down the generation. That's particularly pertinent, I find, in families where maybe there's only one or two in the next generation, and you're hoping to be able to spread it thinner by using trusts. As I think Ed had mentioned earlier, trusts are also a really good way of protecting assets longer term against divorce, the sort of spendthrift beneficiary, the wayward child, and maybe for those vulnerable beneficiaries where you're needing to provide for them, but maybe they just wouldn't be in a position to manage the money for themselves, or for whom an inheritance would actually be quite disruptive. So for some people who are maybe receiving state support or means tested benefits, perhaps if they've got long-term health issues or mental health issues, actually having the money drop into their account as a beneficiary and outright gift can be quite disruptive to that care package because they're suddenly too wealthy to receive it. So it will stop all that funding that may be in place. They have to pay for it all until their money drops again and they can claim it again. So if you use a trust, quite often it's a good way of providing for those people a sort of extra pot of money that can add maybe just the nicer bits around the edges, if you like, and supplement that support that they're getting from the state. And then finally, I do get a certain number of clients who sort of want to make their wills, but perhaps are in a state of flux. It could be that they're in the process of trying to sell their business, or that there's something going on with beneficiaries, or maybe they know that they've got somebody they need to provide for in the immediate future, but that situation's going to change in the sort of coming years, but they're not quite sure when. So for those people, sometimes it's that's stopping them making their will because they're hedging their bets. They're not sure how things are going to pan out. They're not sure how best to structure a will. For those people, it's often a good idea to do what's called a discretionary trust will. And effectively what you're doing there is handing over control of your estate on your death to your executors and trustees with full discretionary powers to divvy things up as they see fit. Usually we would accompany that with a full long letter of wishes, sort of explaining why you've done that and the various different things that you were considering, and that you want them to sort of take account of when they're exercising their discretion. But the benefit there is that it allows them to almost have the benefit of hindsight and to see, well, what is the tax position here? Who do we have in our pool of beneficiaries? What's their personal circumstances? What do we need to provide for? Who do we need to provide for? And to make the best choices as to how to distribute the estate. And these discretionary trusts, as long as they're sort of, those decisions are made within 2 years of your death, they're written back as if you'd made a will on those terms in the first place. And so for tax reasons, they can be a really good way of hedging your bets. And then finally, although we've talked about wills, and obviously wills are a really important thing to have in place, but in reality, they're all about after you've gone, providing you for your family and looking after them. But just as important is about looking after yourself during your lifetime. With increased longevity, people living longer, what we're finding is that more and more people are getting to a point in their life where they're just not able to manage their affairs, either because they can't be bothered, they're not interested, life's moved on, and you know, technology's overtaken them, or perhaps they're just getting to that point physically they can't do it, or mentally they're getting dementia, or some other events happening in their life that just means that they can't deal with things for themselves. So having something like a power of attorney in place can be absolutely crucial. There are 2 types of powers of attorney. There is one which will deal with your property and financial affairs, and within that you can appoint 1 or more attorneys who would be able to deal with your assets. You can give them guidance, you can put restrictions on them, you can make more than 1 property and finance power of attorney so that you can appoint attorneys to do different jobs. And that might be particularly important if you've got a business. So as I said with executors earlier, if you've got sort of certain assets that need specific attention, it may be that you need to make a separate power of attorney just to deal with those assets. And then the second type of power of attorney is one for health and care decisions. And they are becoming more and more commonly used and asked about when you go into hospital, etc. And they allow you to appoint someone, 1 or more people, who would be able to make decisions about health and care if you became incapable of making those decisions for yourself. And they can be quite important for your family to give them that kind of extra power or whatever, and to feel that they have the deciding vote, if you like, in terms of any decision making. As a sort of caveat as to why you should make these powers of attorney, as with wills, not having one in place doesn't stop bad things happening. And if you don't have a power of attorney in place, the only option for your family, if they want to be able to carry on dealing with your financial affairs, or to make any sort of decisions on your behalf, or to sort of with your health and care, if you like, if there's any disagreement, then it means an application to the Court of Protection, and that can be costly, lengthy. It's very intrusive because it involves submitting an awful lot of information to the court, and can cause an extra layer of stress really at a time when it's probably least wanted. And so I would say that just as important as making your will is putting in place lasting powers of attorney.